morning.
Good morning, my lady, my lord. I appear on behalf of the appellant with my learned friend, Miss Gopal. The respondent is represented by Mr. Warnock, King's Counsel, and Mr. Towsing. In terms of housekeeping, mercifully, the documents before the court have been kept quite short. There should, I hope, be two bundles, short core bundle, supplemental bundle, and then an authorities bundle.
Yes, thank you.
So this isn't a case where we'll have to grapple with hundreds of documents.
Perfect.
And it is, as your ladyships will have seen, an appeal of the decision of Costs Judge Nagalingam in respect of detailed assessment. And it's a discrete point, and it's a narrow point, I accept. It is the question of whether the CFA, the conditional fee agreement, that was signed on the 24th of March 2015 was expressly retrospective. In other words, whether it had an express term which allowed for the recovery of fees under it prior to the date of it being signed.
And could I just bottom that out a moment? What do you mean by express term? As long as, if you read the document, it is retrospective, then that is sufficient. It doesn't have to say, you may, this agreement covers fees retrospectively, or covers fees from a particular date, or anything. Does it? One is looking at what the agreement read as a whole means.
Well, we say...
Just so that I understand,
yes.
That might be a discrete point.
Of course.
Another discrete point.
Yes, the second one. Well, we do say that when we say express retrospective term, it has to be a clear and unambiguous term of the contract. And what we'll come on to expand upon is the problematic nature of interpreting solicitor and client retainers on the basis that a client who isn't told explicitly or expressly that a document is retrospective is expected to read the document as a whole and piece together the various parts of that document.
That's called entering into a contract, isn't it?
Well, there are differences, we say. Firstly, the case law uses the wording express.
Right, okay.
Now, whether it is express on its face, if a party is required, and this is another of the points we'll develop, if a party who cannot be assumed to understand or appreciate the way that solicitors fund litigation, or the nuances and intricate methods by which solicitors fund litigation, solicitors cannot expect clients who have not been told explicitly that this retainer is retrospective. They cannot expect or assume that a client will be able to piece together those various parts. There's a wider point here in respect of this particular CFA, because we say, even on its face, it doesn't provide for retrospectivity. So,
well, that's the key point. Because if you're wrong about that, then everything else falls away.
Well, my lord, that is a point in this case, but there is a general point, a wider context to the question, which is why obviously the appeal has been granted to a second appeal. Because if it's the case that a solicitor is entitled to never mention, even informally, never mention at all what the effect of signing a retrospective CFA is, and if the CFA itself is not required to set it out in an express, clear and unambiguous way, then that is a very important point for consumers of legal services, because the effects of that would be that consumers...
The effect of both of those, if the solicitor does not say and if the CFA is not clear,
yes,
that's a very important point.
Yes.
For a wider public.
Yes, and my lord is right to say that there is an and there, because solicitors have obligations under their professional codes of conduct. These solicitors actually incorporated the wording of the code within their CFA, as we'll come to. So they were required under the CFA to give the best possible advice as to costs and to tell the client what the effect of the CFA was. Now, if a solicitor provides information or advice when a CFA is sent to a client and spells it out, to use a colloquialism, if when you sign this, you're going to be liable for, in this case, a success fee going back right to the start of the instruction on top of what you've already agreed to pay. And the effect of that is this, and you would expect the solicitor to advise the client the reasons why that's going to be the case, and also to advise the client as to whether there's an alternative as to that. But if they don't do any of that, if they simply don't mention retrospectivity at all, one cannot assume that a client is in the position to read a contract and piece together those various elements. And this is, I do say, and I don't show...
That's not quite addressing my lady's point or mine. Well, I understand that. But because of the and, what if the position is that the CFA spells it out? CFA makes it clear on any reading of the CFA that it's retrospective. Where then does the point about, assume you're right about
yes.
the failing to spell it out, where does that go?
Well, if there hasn't been any...
Justice Lavender said that didn't affect the interpretation of the CFA. Do you disagree with that?
Yes, we do say that
So it becomes a rule of construction if there isn't an oral warning?
Well, the
How does
fact
it work?
part of our argument, grounds 4 and 5, is that the factual matrix includes the facts known to the parties at the time.
No, answer my question. How does that work as a matter of construction? Say, as a matter of construction, the CFA is clear.
Yes.
As a matter of construction, it's a retrospective. Where does the failure, assume you're right about
yes.
the failure, where does that, how does that affect the interpretation?
If the CFA is clear, so the examples given in our skeleton argument that I'll take the court to, the CFA is clear on its face that what it is doing is presenting the client with a liability which starts from beyond the date of the signature, then a lack of information as to retrospectivity or advice would, I accept, be a regulatory point. But what I do say is that what one can't have, what we say, what one can't have is both a lack of any advice that the solicitor is required to give, and then a CFA which is not clear and needs to be pieced together from various elements of it. I mean, there's also the point in this case, we say, which is that the key fundamental term in this case can be read one of two ways. And so it is, we say, ambiguous.
Can I go back to your first proposition? You
Yes.
say if the CFA is clear on its face, then lack of information stroke advice would be regulatory. So you would then say, I think is what you're saying there, the contract would be the contract and says what it says.
Yes.
But any any redress would be through the regulatory formula, and we're not directly concerned with that today.
No, because
Okay.
so in the example, we can see the examples. I mean, there are two examples, and we're not saying that there is a single form of word that one has to use. That's accepted. That isn't the case. But if, for example, one looks at the case of Ford and Birmingham City Council, which is at page 132 of the authorities bundle.
Yes.
At page 150,
So this was a case about...
Ford and Birmingham City Council was a case where there were two CFAs, and there was a question as to whether, in terms of the second CFA, one could charge a success fee retrospectively.
Okay.
But the first question is the CFA whether it was retrospective or not on its face. And at page 150, paragraph 66, one can see what in that case the CFA said. So in that case, under basic charges, the term was, these are for work done from when you first instructed us until this agreement ends. You are agreeing to pay us for work done before the signing of this agreement, in consideration of our continuing to act on your behalf in connection with this case. Now, that is, I would submit, that is clear to a client who doesn't need to have any specialist knowledge of how solicitors work or solicitors' retainers. It is spelt out what is being agreed. Now, if this CFA said that, and it was clear on its face, yes, my lord. If it was clear on its face, then the question of the advice the client had been given, I mean, it would be relevant to the knowledge of the client at the time, obviously, because the client, if he isn't given proper cost advice as he's required to be given, then it's relevant to the knowledge that he or she has when they sign the CFA. But if what is being said or what is being put to me is that if there is a CFA which is on its face clear, and I use this example as something that is clear, then I do accept that the lack of advice is a regulatory point. But if, as in this case, you not only have a lack of advice, a lack of explanation, and then you have a CFA which doesn't on its face make it clear and unambiguous that what is being done here is to increase the liability, the cost liability of the client hugely in this case. And it's never explained what the effect of that is. And that's why we say it's of the utmost importance that in terms of CFAs and in terms of solicitors' retainers generally, that clients understand what they are signing.
And so, in effect, you are, going back to what my Lord Justice Coulson said, you are seeking to inject into the process of construction, interpretation of a CFA, at least, subjective knowledge and intent. And to diminish the interpretation purely of the words. And of course, the most recent authorities in the Supreme Court, for example, Wood and Capita, put a great deal more emphasis back onto the words. And the words have become almost king, not entirely. But what you're saying, it seems, therefore, is that's not right in the case of a CFA.
Well, in the case of solicitors' retainers, generally, one can see, if one looks at this CFA, which is at page 104, of the core bundle,
Could I just,
yes.
I know it's not helpful necessarily, three people, just so I'm clear. Is your case anything more than this? This contract is ambiguous on the face of it, and therefore I'm entitled to look, we are all entitled to look at parole evidence to interpret it. Is that it?
In the hallowed phrase, your lordship puts it very well, and probably far better than I did.
Well, you'll appreciate that the Lord and the Lady have much greater experience, or
more recent experience in this area, but that was an old principle I used to understand contract law, and that's your case, isn't it? It's ambiguous on the face of it, and therefore we're entitled to look at parole evidence.
And, but it's more, indeed, my lord. But it's also it's more than simply ambiguous, because even if my lords and my lady are against us on the point of ambiguity, it still requires a client when given a CFA, having had no advice on what it means and what the effect of it is, it still requires a client to piece together the various parts of it. And fundamentally, we say that cannot be an express term in the context of CFAs and solicitors.
Okay, all right. Sorry, I interrupted you. We wanted to take us straight to the contract.
So it's at page 109 of the of the core bundle. One can see, and this is the CFA. One can see paragraph 6. Paragraph 6.1 Roman numeral 5. The firm agree and contract that one of the terms of this CFA is that they will give the client the best information about the likely costs of the case. Yeah. That is taken from it is the wording of the code of conduct, essentially. That's what's required.
Will you, again, forgive me for interrupting. No. It seemed to me, my reading of this, that a key question is what is meant by the word claim.
Yes.
Throughout this document.
Yes.
And that's defined on page 1.
Yes.
As meaning the application by the client as liquidator, in respect of which this firm has been engaged since the 30th of March 2012.
Yes.
Do you accept that that's what we're talking about? Whenever we see the word claim in the document, that's what it means. Since,
yes.
Obviously, since what's been going on since the 30th of March 2012.
Yes, but as I'll come to, and one of our grounds is that word, that definition can be read one of two ways. At least one of two ways, because we say that's an ambiguous definition. Because what it's not saying, and I'm getting ahead of myself in terms of my submission, what it's not saying, it's not linking in any way the fact that an agreement which has on its face the date of 24th of March 2015 essentially is meaning that the client is taking on a significantly higher liability for costs. Because we say that term should be read as simply saying, this is not a CFA and a new claim. We've been at this for 3 years. And so when we're talking about the claim, we're talking about the matter that we've been dealing with on your behalf for 3 years. Now, the respondent's argument is that when one reads that and then reads basic charges, then goes to Part 4, successful claim, and pieces those all together, that gives rise to the...
Piecing it together, is it? 2, what is covered by the agreement, the claim.
Yes, but it's 2, what is covered by the agreement, but it's also 4, payment of fees to the firm, which gives the trigger for the payment.
Assume I'm an ignorant client, and I look at this and I say, well, what's covered by the agreement? I see the claim.
Yes.
And I remind myself what the claim is because it's defined.
It is, and you remind
it's the liquidator's application on which the solicitors have been working since the 30th of March.
Yes, that is the claim, and
that's what's covered by the CFA.
And the client says to themselves, well, okay, that's the claim that they've been working on. We already have a retainer for that claim. This is another key point. This is not this is not the first time that there's been an agreement between the solicitor and the client.
No, we understand that. So what is covered by the agreement? The claim.
Yes.
And so what does the definition of a claim mean, as far as you're concerned?
The claim in these circumstances means, we say, is simply, it is a description of the claim going forward. So if we say
But
this,
that's not what it says. How does one read and interpret the definition of the claim, Mr. Dunn?
that it is a description of the case that the solicitors have been engaged in for 3 years.
Okay.
And it's there, I say, because it's clear that this is not a new case. This is a case where there is a retainer already. This is a new retainer. It's a new CFA, which is going to cover the matter from the date on its face. But the reason that is there is because that's all it's saying. It's saying that this is not a new claim. This is the claim we've already engaged in.
You say that it would cover it from the date of this
Yes.
agreement. Where does it say that?
Well, it says the deed of conditional fee agreement is made on the 24th.
And I understand that, but where does it say that the work done by the solicitors is only the work from that date, the 24th of March?
Well, there is a presumption, I say.
Well, leave aside the presumption and the legal basis for that. As a matter of interpretation, which is what we're talking about, where would I get that from?
Well, my lord, if one is looking at it as a matter of interpretation, then the presumption, I say, is important. Because if one is starting from the point...
Just look at the words. We come to the question of the presumption and its force, because we understand that in some ways is a high watermark of your case. We understand that. But as a matter of the words, my question was simply, where would I get from this agreement that it's only from the 24th of March 2015 going forward, given the clauses that we've just looked at?
Well, because it doesn't say anywhere else that it is retrospective. It doesn't say that it's retrospective.
No, well, we understand that it doesn't use the word retrospective.
Yes.
And that was one of the big arguments below. But leaving that to one side, and you may make that submission, but leaving that to one side, as a matter of the words, there's nothing here date-wise that says 24th of March onwards. The only other date that's given is the 30th of March 2012.
But it is not giving that in the context of the
Well,
liability for costs.
so that's the submission that you have to make as to why you say it's ambiguous.
It's not. I mean, again, one looks at the wording that I've taken your lordship to in the Birmingham case, and it's an example. I'm not suggesting that there is a form of words, but using that as an example. In that case, under basic charges, it explicitly sets out you are agreeing to pay us for work done before the signature of this agreement.
Yeah.
In this case, there is no suggestion that there is a liability to pay costs for any time prior to the signature, and it isn't the case that one looks at these in my submission and if it's silent, then it will be a retrospective agreement. Obviously, that can't be right.
No. That's why I put to you that there are two dates in play. There's the date of the agreement, and then there's the date in the definition of the claim.
But it particularly in this case, where there hasn't been any advice given at all as to what the consequences.
Just looking at the words at the moment, we
Yes.
we have to try and
Yes.
break it down. We're just looking at the words.
The only way that could, I would say, that could be an express term of retrospectivity is if it was clear that what the definition of claim was doing was essentially signing up the client to a cost liability before the date of the agreement. But it doesn't say that. It doesn't say that at all.
Mr. Dunn, again, forgive me. The Lord and my lady are halfway around the course, and I'm still at the first hurdle. So I'm at the definition phrases still.
Yes.
I looked at claim. It seems to be possibly a more important defined term is basic charges,
Yes.
which I note is as it were the equivalent of the clause that you took us to
Yes.
in the Birmingham case.
Yes. That's right.
And what that says is the charges done by, I'm just hopefully not doing violence to it by paraphrasing, charges of the firm for the work done by the firm for the client in relation to the claim. So, where's the ambiguity there, do you say?
Well, the first point is that in relation to the claim as reflected in the firm's standard terms of engagement letter, a copy of which has already been supplied to the client, but means the charges for the work done by the firm in relation to the claim, all that does is simply take you back to what the definition of the claim is. And I accept, if the court finds that there is only one way of reading that definition, and that a lay client who doesn't have any particular knowledge of legal matters would read that in only one way, then it won't be ambiguous. But I say it cannot possibly be the case that you can only read that in one way. And where the basic charges is precisely the point at which a CFA which is expressly retrospective should set out in clear and unambiguous wording that it includes costs going all the way back. Here it's 3 years worth of costs, and it is just looking at this on a practical basis. In this case, the hourly rate that was being charged was £335 an hour. By signing this CFA, what the client has signed up to is a 50% success fee or a 70% success fee, depending on when the claim settles. If it settles at trial, it's a 50% success fee. If it settles before trial, sorry, other way around. Settles before trial, 50%, settles at trial, it's 70% success fee.
But this went through to a judgment.
Yes. Now, the practical implications of signing this document is that £335 an hour hourly rate essentially rises to £569 an hour. And not just going forward from the date this is signed, it rises for every hour of work done for the past 3 years. So one can see immediately why it is so important that solicitors inform and advise their clients. And this isn't just a regulatory point. As I say, this is in the document itself. There is an obligation within the CFA to provide the best possible advice. And also within the CFA, on page 111 of the core bundle at 15.1, one can see that it includes the words, "The firm has already drawn the client's attention orally and in writing to the effect of this agreement, and in particular the following matters." Small Roman numeral 2, liability to pay the firm's costs and expenses. Well, the liability to pay the firm's costs and expenses, as I say, has risen from £335 an hour to nearly £570 an hour. On the basis of this, there has been no advice given whatsoever. And this is why I say one can't simply move away or disregard what the client is told and what the client knows in solicitor-client retainers.
15.2 says the client acknowledges that the matters referred to in clause 15 have been explained orally and in writing.
Yes. Which I don't think is in dispute, that they haven't been explained orally and in writing.
That's not in dispute.
Well, if there is, we'll have to be taken
I'm not sure that was in fact explored below, and there's been no finding by the costs judge about that. The case wasn't quite put that way.
Well, I can take.
We're not here to deal with appeals on fact, anyway.
I can take the court to the formation, what was said, precisely what was said in terms of the CFA.
I think the point that's made is whether there are any findings.
No, but there is no suggestion. I mean, if there is a suggestion, well, it's accepted that the client wasn't told that this was a retrospective CFA, but the argument is whether the document on its face has an express clause. We say no, the respondent says yes.
When you say the client,
Yes.
you mean?
I mean Mr. Ingram, who's the client of
Yeah.
of
Yes, I'm
Boys.
sorry, that was asking a very basic question.
No, what,
Do we ask? Is it relevant to your case to consider what Mr. Ingram understood?
it's relevant. It is absolutely relevant to the case to consider, as part of the factual matrix, what his knowledge was at the time, and what he was told. Which is why my intention was to very briefly go through what he was told, because it's instructive to see how.
What is evidence?
No, not his evidence, but the
Findings of fact made by the cost judge, yes.
In the core bundle, there's the evidence of the solicitor for Boys Turner, who are Mr. Ingram's solicitor.
What was the finding about what Mr. Ingram understood? Mr. Dunn, if I'm taking you out of your course, then
No.
please come back to that in due course.
It
It seems to me to be fairly central to your case, isn't it?
I hadn't thought it was.
If I'm barking up the wrong tree, Mr. Dunn, just say so.
No, not at all.
I don't want to distract you. But
If it helps, it's paragraph 167 on page 101 of the core bundle.
Thank you.
Well, that, with respect to my learned friend, isn't what was understood at the time. That is what Mr. Ingram said.
That's what the cost judge has found.
No, my lord, he says these evidences.
Yes. And that's consistent with the common pattern of work. That is all relevant when considering the background knowledge.
Yes, and we say that.
I mean, the cost judge's analysis of the facts effectively is between 150 and it's both the facts and the interpretation.
Yes.
It's about from 150, but he places great importance on the past working relationship, hence 161.
Yes.
But whatever they are, these are the findings of fact that he made.
Well,
There are no others.
what the judge says at what the judge finds at 168, 169 is that the email from Mr. Branson, as I say, who was the solicitor for Boys Turner, to Miss Kicks, who worked with Mr. Ingram, that email drew attention to the fact that he had amended the definition of the claim and stated that this amendment should not be controversial. That is relied upon. That was relied upon at first instance and is part of the cost judge's findings. But of course, that's extraordinary argument for the respondent to make. That essentially sending to a client a CFA which they say is retrospective, amending the term which they say gives rise to the retrospectivity, and saying to your client it's not controversial. I mean, clearly it's important, even if it's not controversial. But this is all about consumers of legal services and how solicitors are able, or should be able, to sign consumers of legal services up to retainers, which are highly prejudicial to clients. And on the arguments of the respondent, essentially, this CFA does all that it needs to do. Now, your ladyship might agree with that, But there should be no doubt that that is potentially extremely prejudicial to consumers of legal services.
Yes. You in that submission,
Yes.
you allied is not quite the verb I mean, but you allied. You use at some point in that submission you use the word client, and at some point you use the word consumer.
Yes.
And I'm just troubled as to how you say the prejudice to Mr. Ingram arose here. If he's
Yes.
who we should be focused on as opposed to your client.
Yes, that is, my lord, an important point, because we don't use the word consumer as they would in the Consumer Rights Act, for example. That's not what we're saying, and has never been part of our case.
Okay.
We're using the...
I was going to ask you that, and it follows on. You use the word consumer.
Yes.
Where are we accessing these strands which get us to a situation in which supports your last submission? And your last submission, it seemed to me, might be, and I wanted to ask, and I think that's what my Lord Justice Baker was also doing, ask where those other strands upon which you rely come from.
Yes.
We've already discussed the regulatory regime, but you said that in relation to that, if the contract was clear, then on its face, then lack of information advice would be a regulatory matter, and I got the impression that for our purposes that would be put on a shelf for now if the words were clear. But are you saying that the two strands, because you say the words aren't clear, the two strands that assist you are regulatory matters and consumer matters?
There are multiple protections for clients of solicitors. So there is the Code of Conduct of Solicitors. There's the Solicitors Act itself.
Yeah.
And there are also in CFAs such as in this one, there is the wording that incorporates the language of the Code of Conduct into the contract itself. So one doesn't have to use the definition of consumer, which one does, for example, in the Consumer Rights Act, which is about someone acting outside their business. Here, there was an obligation of the solicitors to provide their client as a consumer of legal services with the best possible information as to costs and the information as to the effect of signing the CFA, what the effect of it was. We don't have to, we say, go to the Consumer Rights Act to add anything additional, and it would be quite wrong to, we say, because one cannot assume in these circumstances when a solicitor is contracting with their client, one cannot assume that the client is has any knowledge of matters such as CFAs and matters such as how solicitors...
But in this case, I take that point, but in this case, this client, the finding was, as I read it, this client did understand that it was retrospective. So, why are you entitled to object to that?
Well, there was no. It's important actually to consider what that means. Certainly, the evidence years afterwards was that he understood that it was retrospective. But there's nothing to suggest, and certainly in his live evidence, Mr. Ingram accepted that he didn't that matters such as all CFAs were outside his area of expertise. So there isn't a finding that at the time the contract was entered into, he knew it was retrospective. It's important to note how this came about in that respect, because Mr. Ingram and Mr. Branson, who was the solicitor, understood that they were in agreement prior to the CFA being signed on a private retainer, which wasn't a CFA, but they had what was called a gentleman's agreement, so it was an oral CFA, which is unlawful. So Mr. Ingram and the solicitor were acting on the basis of an unlawful retainer.
And where's the finding of fact that says that? Because I understand that that's your submission and that's set out in your skeleton. And I did look at the cost judge's findings of fact because it seemed to me there was a gap between the submissions and the findings. I mean, you've just used the word unlawful, which you use in your skeleton.
Yes.
Where's the finding that it was unlawful?
Well, at paragraph 115, Mr. Tausig.
So paragraph
115.
That's not the findings, though.
No, but this is what
The cost judge's this is a second appeal.
Yes,
Mr. Dunn.
I accept that.
You are bound by the findings of fact made by the cost judge. Cutting it short, I'm not aware that the cost judge found that there was an unlawful agreement.
The cost judge didn't need to make any finding on that point because it wasn't a point in dispute. It wasn't a point in dispute in the case. And
so you say it's agreed that there was an unlawful agreement?
well,
Is that right?
If paragraph.
Sorry, is that right?
Yes.
Mr. Warnock, do you agree that there was an unlawful agreement?
No, we refer
Fine.
to what the
All right,
cost judge
that's
said.
fine for the time being. I don't want to interrupt Mr. Dunn's.
Paragraph 115. This is what was submitted to the judge. Paragraph 115, Mr. Tausig stated that Boyes Turner knew that they were working on the basis of an oral CFA and not a signed private retainer.
Yes.
And an oral CFA is unlawful under the Courts and Legal Services Act. That can't be in dispute. And in fact, that was the entire reason why this matter arose, because in cross-examination, Mr. Branson said there was a gentleman's agreement, but that wasn't in dispute. That wasn't a fact, that wasn't a matter that had to be dealt with, because, I mean, it's clear from what the judge records. So, unless my learned friend is going to argue, which would be a bold argument indeed, that an oral CFA is not unlawful, it wasn't in dispute.
But Mr. I've slightly lost the plot, and I apologise for that. So please bring me back into the appropriate groove.
Yes, I'm afraid I have as well. My apologies.
One way or another, there was, it seems, a gentleman's agreement, whatever one wants to call it. And then there was the document that we have.
Yes.
And it would seem that the definition of claim was changed and it was said to be uncontroversial.
Yes.
And that definition goes back to the beginning of the arrangement between the parties, put it that way. So, in fact, the cost judge, having mentioned the oral agreement at 115, at 167 says that Mr. Ingram's evidence was at all stages he, as the claimant, understood the written CFA would be retrospective and consistent with previous instructions and consistent with the common pattern of work that, in fact, work gets done and you remain unpaid until there are funds to pay you, because that's the nature of the beast. And so what's being said is there at 167, yes, there were previous instructions. Presumably that's a reference to the fact that there was an oral agreement, which you say it was not lawful. But whether it was or it wasn't, what's the relevance of that? But that's why I've lost the thread. Why does it matter? Given that these parties knew that they have been bumbling along, put it that way, together for some time, and now they enter into an agreement which Mr. Ingram says he knew was retrospective, and we know the terms of it. Why does it matter that before that, if they'd already agreed something, it was impermissible?
Well, it matters. I mean, it's part of the reason why Mr. Justice Lavender dismiss the appeal to that extent.
Yeah,
so it matters on that.
I just need you to redirect me precisely to why. That's all.
If the parties, it is grounds 4 and 5
Yeah.
are attacks on the judge's findings on the matrix of facts. And I should say I was slightly blown off course, but my
I'm sorry.
no, please. My learned junior will be taking those two grounds 4 and 5. But it does matter because if we look at what the parties knew at the time, there is no suggestion and there's no finding of fact that at the time the parties knew that they were operating under an unlawful oral CFA. I don't make any suggestion that's the case. They didn't. What they had was a private retainer, and then they had, but they had agreed outside of the written terms that actually it would be a CFA. When they come to enter into this CFA, there is no requirement, no commercial requirement, no requirement at all for them to make this CFA retrospective. There's no need for it to happen at all. They have, in their minds, they have a retainer which deals with the pre-CFA work, and this retainer, I would submit, would deal with the post-CFA work, so going forward, prospective. So it is important when one considers what was known to the parties at the time, because, for example, if the parties had no retainer whatsoever, and they were just doing, bumbling along for 3 years, and suddenly someone said, "My goodness, we need to we need to regularise this."
You need to firm this up, yeah?
Then one could imagine that a retrospective CFA would be required, or something would be required to take account for that 3 years of work. But not in this case. That wasn't required. There was no imperative or incentive. In fact, the only effect of that, of the fact that the claimant solicitors, that the respondent solicitors say that it was retrospective, the only effect of that was to increase Mr. Ingram's cost liability substantially. That is the only effect of the fact of there being a retrospective CFA.
In effect, you're saying that this is called a fast one, using local language, because they couldn't have enforced their oral agreement, and so they made this retrospective. That's in effect what you're insinuating.
It's absolutely my fault if that sounded like what I was insinuating. I'm not insinuating conspiracy. I'm insinuating the other thing, which I won't say. But what I would say is this: there's no suggestion that anyone knew that the retainer that they were operating under was unlawful. So I don't say that these solicitors pulled the fast one and put in this CFA which was retrospective. In fact, I say quite the opposite. The parties understood that there is this retainer going forward, that covered everything up to this point, and therefore they didn't agree a retrospective CFA. So, I mean, to the benefit of Boyce Turner, I'm saying they absolutely didn't do that, because if they had done that, if they had known, for example, that there was an unlawful retainer in place, and they had put in a CFA which was explicitly retrospective, that would be a separate issue. But they didn't. And I do say this is the important point, that I'm not suggesting that there is a form of words that one has to use, but I am suggesting that what needs to be said is not unduly onerous. I'm not suggesting that anything other than the examples that I give in our skeleton argument needs to be said. All it needs to do, essentially, is specifically link your cost liability to a period of time prior to the CFA being signed.
And why doesn't the definition of claim do that?
Well, it doesn't do that because it doesn't specifically link the payment of fees to a specific time. But also it doesn't do that because I say that if one can read that as simply describing the claim rather than essentially providing the trigger or mechanism for a retrospectivity clause, then it's clearly ambiguous. And I would go so far as to say, and the court may disagree fundamentally with this, but I would go so far as to say it's only if that definition can only be read in the way that the respondents are suggesting, that it is clear and unambiguous, so as to make this an express agreement.
Well, the cost judge's finding,
Yes.
I think, was expressed on this point in the last sentence of paragraph 178, wasn't it? The CFA simply permits remuneration for work done by the solicitor, where that work relates to the claim with no distinction drawn between past work and future work.
Yes.
So his finding was it covered past work and future work because that is that was how the claim was defined in the contract.
Yes.
And then he adds 179. Now, I'm just wondering how to characterise what you've got to do in this court
Yes.
to succeed in an appeal given those findings.
Well,
What have you got? I'm just wondering what the hurdles you've got to get over.
yes. Right. Well, this is actually a point that we fundamentally say that the cost judge is wrong on. He's wrong to the extent that it's an impermissible conclusion, because
Forgive me for just which bit is impermissible.
where he says where the cost judge makes a distinction between counsel's earlier CFA, no express term, and the solicitor CFA. The CFA simply permits remuneration for work done by the solicitor where that work relates to the claim with no distinction drawn between past work and future work. Well, that is, we say, entirely the point. There has to be some express, well, it's almost some clear language that what is being contracted for relates to both past and future work. And if it's, you cannot, in our submission, cannot just have essentially silence. So if the solicitor simply doesn't say anything about past and future work, it cannot possibly be right that a lay client...
But that's not this case, because we've got the words added in the definition of the claim. So it can only be, on your best case, ambiguous as you submit.
Yes.
It's not a case where it's not in there at all.
Well,
Isn't the cost judge right to say it doesn't draw a distinction in the sense that it's simply dealing with the claim? And the claim as defined is the work done since March 2012.
My lord, no, I wouldn't accept that the cost judge is right about that, because what the cost judge is essentially saying is that where it says, so in the CFA itself, where it says means the charges of the firm for the work done by the firm for the client in relation to the claim, there's no, what the cost judge is saying, there's no distinction between past and future.
Yeah.
Your point is there has to be.
My point is that absolutely there would have to be, because if there isn't, juxtapose, and again I use Birmingham versus
Sorry,
Ford.
my point was a slightly different one.
Sorry.
My fault.
The date from which the work starts is defined in the claim.
No, my lord, I don't accept that.
Well, fine, that's the point. But all the rest of it doesn't really add anything, does it? We come back to the words.
Well,
we come back to the words, the definition of the claim, whether or not that is a clear definition. What I'm anxious to do, though, is to tease out a bit more whether you say that in some way we go beyond normal rules of interpretation. Because you keep using the word express.
yes.
You keep suggesting, I think, that any whiff of ambiguity somehow means it all comes crashing down, neither of which are canons of ordinary construction. So are there different rules of construction because this is a CFA?
There are different. There are certainly different rules that apply to interpretation of contracts between solicitor and client. I mean, there are, for example, the case law regarding informed consent, for example, as between solicitor and client.
But those are usually on specific points. Here we're just talking about a very simple point. Was this CFA retrospective? We've got very few words which, on the cost judge's view and Mr. Justice Lavender's view, clearly meant that it was retrospective. You say not, and you've made your submissions as to why you say it's ambiguous, and I think we have those.
Yes. No.
But what I'm just anxious to identify is whether there's some different, steeper, more onerous test that we have to apply that means that, well, if this was an ordinary building contract, let's say, it might be retrospective, but you've got to do more than that because this is a CFA.
Well, yes, I do say that's the case, and I'll come to why I say that's the case, because it's essentially to do with the presumption as a starting point, and also it's to do with what I say is the meaning of express in the context of a solicitor-client relationship.
Right, so let's go to the presumption.
Yes, so if one turns to page 71 of the authorities bundle, this is the Moto and Trafigura case. Is it 71? Tab 17, my apologies. Page 270. And you'll see it highlighted, my lord, my lady, at D. So it's paragraph 61.
Paragraph 61
Yes, my lady.
Did you say it had been highlighted?
hasn't.
It should. It is.
Never mind. Yeah, no, I'm afraid that hasn't come through on my copy.
Oh, I do apologise.
But so it's paragraph 61.
Paragraph 61 on page 270. It starts with "as for the judge's conclusions." And it's Lord Neuberger says, as the claimants appear to accept any CFA which limits the client's liability to work done after the CFA is entered into, cannot extend to work done before that date. Equally, although of course solicitors and their clients can agree terms otherwise, the natural presumption in a contract by which a person engages a solicitor to act for him must be, in the absence of such a term, that he is agreeing to pay for work done in the future, not for work already done.
So if the contract is silent, that's the presumption.
Well, no, I wouldn't accept that, my lord.
Well, okay, why not?
I would submit that the presumption is that that solicitors' retainers with clients are forward-facing, unless there is an express term which sets out otherwise. Now, if your lordship's relationship are against me on whether there's an express term in this CFA, that is a slightly different point. But as a proposal, I say that is it's not simply a question of unless it's silent, there's a presumption. The presumption extends unless there is this express language, and it has to be expressed. And that's from, I mean, that goes back to the Holmes and McAlpine case, which I appreciate is a High Court case, but that's at page 59 of No, it's not.
No.
Holmes is 115, tab 13.
My apologies. And it's page 128, paragraph 19.
Paragraph
19,
19.
on page 128.
Yes, this is about the difference between. This was about backdating.
Backdating and a retrospective agreement. Yes, that's right. I should just.
So
There was a question mark over whether retrospective CFAs were even lawful. Then the next phase, which was the Ford and Birmingham City Council phase, was whether one could recover on an inter-parties basis success fees going backdating. But this is, as my lord rightly says, this is about whether a backdated agreement is permissible. And of course, a backdated agreement is not. But what the judge is saying at this stage, sitting with two assessors, I should say, what the judge is saying at this stage is essentially saying that it's not retrospective; it was backdated, which is a very different thing. And then when the judge says a properly drafted agreement, he is talking about a retrospective agreement. What a retrospective agreement would say.
And you say it says it would expressly provide for its application to work done before the date agreed.
Yes,
and that's where you get your expressly from.
Yes, but also it's important and instructive to look at what that's actually saying. It's expressly providing for its application to work done, and that's a theme that one sees throughout the examples in terms of the cases, because it's all about setting out in terms of work done what the CFA applies to. There's an example at tab 24 in Friston on costs, which is at tab 24 of the authority bundle at page 440. And this is at 29129. And in the preceding paragraph, one can see, as my Lord Justice Coulson says, that there's a reference to the Holmes and Alfred McAlpine and backdating versus retrospectivity. Yeah. But then at 29129, the author says a conditional fee agreement may expressly cover work carried out before the agreement was made. An agreement that covers, and this is in quotes, all work from the date of instruction, including work carried out before this agreement was made, will have made express provision for retrospective application. There's then discussion of a retrospective effect may arise by implication. That isn't in dispute in this case. There's no argument that there was an implied term or anything like that.
And that rather militates against your argument that it has to be expressed.
Well,
it doesn't, according to Friston, at any rate, it can be implied.
No, well, I don't accept that it can be implied.
Oh, right,
and
okay,
one can see there's no authority.
We realise, Mr. Dunn, you disagree with a lot of people in this case about a lot of things. But you would have to disagree with that, wouldn't you? Because you're your argument is it's got to be express.
Yes, and I haven't that isn't just me having a sort of a moment here in this court. We have argued throughout that it's not possible to imply a retrospective clause.
The footnote indicates that the authority of that is an obiter observation.
Yes,
That's your point, isn't it?
there's no authority on the point, and it's certainly even before the cost judge that was argued by us that there isn't an ability to do that. I should say, in fairness to the respondent, that it was argued by them that one can imply a term, but in any event that wasn't a matter that had to be dealt with.
And it's not a matter for us.
Not at all, because there's no suggestion that there was any implied term, and if there was such suggestion, I would argue against it, because as my Lord Justice Coulson says, my argument is that it has to be an express term. So luckily, I have argued throughout that that one can't have an implied term. But again, I appreciate this is a practitioner's book. But it's instructive to look at the way that it is worded in respect of the example of retrospectivity. It is, I say, that is a good example of an express provision, because it links precisely the work carried out before this agreement was made, and it tells the client precisely and expressly that by signing this, you are taking on that liability.
And so the issue for us is simply whether, in respect of which the firm has been engaged since the 30th of March 2012, is sufficient.
Yes.
We stub our toe on that point, I think, because it is,
Yes.
I think, quite a simple point.
I've probably made
He
it far
said
more
hopefully.
complex than it needed to be. But
When combined with what it says in basic charges, that the charges are for work done for the client in relation to the claim with a capital C, and then and whether that is enough put together.
But there is. I mean, I have gone over ground one, but there is a point that we do raise in ground two, which is. And this is really the point that there has been some discussion between myself and your Lordship's relationship as to whether, as a concept, in the context of the solicitor-client relationship, whether an agreement that requires the lay client to read the document as a whole and come to the conclusion that it's of retrospective effect, whether that is sufficient, whether that can ever be an express term.
And that's what we've been teasing out about express and what the other influences you say are on how to construe the contract.
Yes. So we say that just as a matter of, it cannot be the case that solicitors would be entitled to not provide any advice as they're required to under this contract. So we can even leave aside, as I say, the code, but not provide appropriate or sufficient advice, but then leave it up to a client. And one cannot assume, I say, that even a sophisticated litigator or a sophisticated businessman, I'm not suggesting that it has to be a lay client in a modest accident claim, for example. Even a sophisticated businessman, dare I say it, even some solicitors are not fully au fait with the intricacies of the cost rules and funding. So it has to be the case. All the examples that are given is where it is set out, and as I say, linked to the definition, and it's set out clearly so that anyone reading, for example, the definition in Ford, the example given in Friston on costs, anyone reading that, no matter how sophisticated or unsophisticated, will walk away from that contract knowing that it applies retrospectively. And that's of crucial importance generally for clients, but it was of crucial importance here because, as I say, it increased everything retrospectively every hour spent by 70%. And that is a very important term. If one uses, as an example, look at it in the context of another type of contract. If there was a term which was about to increase your costs by 70%, on top, and there was a requirement that that had to be an express term, would one really expect a lay client to be able, or to be required even, to piece it together from the various definitions? Or, as I say, would one expect, when the term has to be expressed, that it should be set out in a clear and unambiguous way that means that anyone who reads it only has one interpretation of it and can sign the document knowing what they're letting themselves in for?
So you say it's just a description, what's in the claim, how it's described.
I say it's just a description, and if I'm wrong about that, it can be read as just a description.
Okay.
So even if your lordship, your ladyship don't agree with me, it can be read that way.
It's quite an unusual way to describe a claim, isn't it?
No, I would, if it was a brand new, CFA, for example, if it was a case where solicitors have only one case with this particular client, and it was a brand new retainer, then it might be unusual. Although, as we've seen from the judgment, when it's sent over, it's said specifically not to be controversial by by Boyes Turner. But it's not. It isn't an unusual way to describe the claim if this is a relationship between Boyes Turner and Mr. Ingram, where they might have lots of claims going on, and where there's already been lots of work done in this case.
But by this point, the claim had been issued, had it?
Yes, it would.
So if it was just a descriptive phrase, you could put the claim number in, couldn't you?
You potentially could, although I think there was a number of, I would have to go back and look, but I think there was a number of different applications in this matter. But yes, you could.
Or you could describe the nature of the claim. And that's, I don't know, isn't that how people most often describe a claim, what the claim is about? It's quite odd to say this is the, not odd, I mean, isn't it odd or striking that the phrase used is by reference to what the date on which the firm has been engaged, if it's just a descriptive phrase?
I say that's not an odd way of putting it, because, as I say, this is at a point when there is an existing retainer which covers this work. This is the other crucial point. Leave aside whether it was an oral CFA and whether it was unlawful or not. That's immaterial for the point I'm making now. This is a case where the solicitors and the client already have a contractual agreement. There's a contractual retainer which covers them, which covers this work.
And other work.
Well, no, which covers this particular
Just this
work.
case. No.
They may well have other retainers for other strands of work, but they certainly have a private retainer that covers this work. So you are dealing with a situation where you are already contracted to undertake this work, and what this definition is doing.
But you said that's unlawful. That's an unlawful agreement.
Well, yes, but there's no suggestion that anyone knew it was unlawful.
Yeah. Okay.
And in fact, the retainer, the private retainer, is in the core bundle, in the fund. It's in the supplemental bundle rather. I'll leave the court unless you wish me to take you to it. But it was also the case in, for example, the cost pleadings, that it was pleaded that there was a private retainer and then the CFA. The question was whether the CFA was retrospective. But there isn't any dispute that these parties had a contractual agreement in place. So if you are a solicitor seeking to contract with your client in a case where there's already a retainer which sets out your hourly rates, what you're being paid, everything else, I say that it's not unusual at all to make it clear that what this is covering is the case where we already have that retainer, and it's describing the case, but it's not saying, but we're going all the way back and basically we are essentially that retainer becomes null and void. This is replacing it, for example.
But surely, on the assumption that there's already an existing retainer, you wouldn't add in those words. You would just refer to the claim against MSD in liquidation, full stop.
Well,
you wouldn't refer to the fact that the work had already been done, if it was designed not to be retrospective, you wouldn't have those words, because you'd say, well, there already is a retainer, so I don't need to worry about up until the 24th of March 2015. So isn't the inclusion of those words actually against you, because it means that although there was, let's call it a private retainer, although there was a private retainer, that the addition of those words in this definition was clearly designed to mean that the CFA was retrospective, and it covered that work done.
Well, there's two answers to that. Firstly, even if it was intended to do that, the question of whether it's an express and unambiguous term.
Well, I follow that. I'm just dealing with your argument that this is all concerned with the work done, and that already is a retainer. And I see that. Yes. If there already is a retainer, then you wouldn't add these words if you were not intending to make it retrospective.
Well, I wouldn't accept that, because it's ensuring.
Why add it if there's already a retainer that you're not disturbing?
Well, if we can't, one could easily ask as easily, why not add a clear definition of what basic charges are?
I'm asking you about these words.
But I don't know why that was added. Of course, I don't know why that was added.
No,
but if there's only the fundamental question, I say, is that the only way that a lay client could interpret that? Now, as I say, if your lordships, your ladyship are against me on that, and the finding is that a lay client reading this document, the only way they could interpret that would be...
We're not dealing with a lay client, we're dealing with Mr. Ingram.
Well, he is a lay client, he's not a lawyer.
Yeah, he's not a lawyer.
No.
But you accept, I think, that he wouldn't fall under the definition of consumer in the Consumer Rights Act.
He wouldn't, but...
So an informed client.
I would, well, the definition of consumer under the Consumer Rights Act is anyone who's not acting in their main area of business. And he clearly is. You might have a small businessman who wouldn't be a consumer under the Consumer Rights Act, but you couldn't assume, I would say, that a small businessman
we would just be anxious to deal with this case on these facts. Last month, I was asked to do a talk to the Association of Cost Lawyers.
Wow.
Very enjoyable. my lord is amazed.
Is it available on
and one of the points and one of the points I made was, one of the difficulties in cost cases is that advocates tend to say, certainly to this court, that the point that arises affects hundreds or thousands of other cases, and if you decide against me, then the whole costs edifice will come crashing to the ground. So you'll forgive me if I'm slightly, sceptical about the damage done. I mean, obviously our starting point, very often our finishing point, is simply the particular facts of this particular case and the issues that arise in this particular case.
Yes. Well, my lord, firstly, I wish I had seen that before. I could have made some comment at the outset, and it would have helped me, no doubt.
I doubt very much that it would. It just is a feature of cost cases in this court.
Yes, it is, and I fully accept that sort of hyperbole and that the sky will fall in. I appreciate that. It gets said a lot in cost cases. I'm not going that far, but what I am saying is that that there is an importance beyond this case. There is an importance beyond this case, and that if it is the case that this is a permissible retrospective CFA, that does have potentially significant negative effects in terms of the protection of consumers of legal services, because it would require, essentially, I say, it would require solicitors to make an assumption as to the knowledge of their clients, and whether they need to be clear, or whether they can, essentially, as the respondent says has happened here, whether they can leave it up to the client. But my lord, I would I would briefly come back to my point I was raising, which was there is a difference between, for example, consumers under the Legal Services Act, where, as I say, you could be a small businessman who's incurring legal services in the course of his business. But Mr. Ingram, again, this is in the transcript, I can take your Lordship's relationship to it, but in terms of, for example, the oral CFA, he said that was outside of his expertise. Well, of course it would be. I wouldn't criticise him for that. He is not a solicitor. He is probably, I'm sure, extremely knowledgeable about what he does. But there is a danger in assuming that simply because someone engages solicitors, even regularly, that they are knowledgeable about the implications of what a retrospective CFA is. And the easy answer to all this is simply to put in a form of words which make it clear. And there is nothing, as I say, there's no prescriptive form of words I'm suggesting, and there is nothing onerous I'm suggesting. I appreciate in terms of the advice that should be given, that's a slightly different point. But in terms of the wording in the CFA, there's nothing unduly onerous, but it is important in a wider. I appreciate I'm now doing precisely what my Lord says everyone does, but I hope I'm doing it a rather more hopeful.
So can we dial down for a second, and have we got all your points in relation to express, which is ground one, relying on a combination of terms? I think we've understood your points in relation to that, and the definition of claim itself. And then how that is used. I think we've got those two. Is there anything else you want to add about those?
I'm very grateful. There's only one element that I do want to deal with very quickly, which is a point that appears in my learned friend's skeleton arguments about the wording of the phrase "the work done" and whether that and so it's at in page 60 of the core bundle, and it's at paragraph 68 of my learned friend's skeleton argument. There is an argument raised.
I'm very sorry, Mr. Dunn. Give me that reference again.
It's page 60 of the core bundle.
60.
And my Lord, it's paragraph 68.
It's the done or to be done point.
Yes. Indeed, my lady. Yes, it is. Just as an aside, I don't think there's any suggestion that this is a contentious business agreement, not least because it was assessed, and that's not what one can do with contentious business agreements. But generally, I do say that it's not a helpful point. Frankly, it's not a helpful point either way, because
basic charges. It says work done.
First, for two reasons. Firstly, the nature of a CFA is that the cost liability is triggered only in the event of success. So there isn't a cost liability, strictly speaking, or even generally, until there is success at some point. That's why I would submit work done is a perfectly reasonable way of setting out what the basic charges cover. The other point is to differentiate between, for example, Ford and Birmingham, where CFA in that case specifically set out work done or to be done. This CFA doesn't do that. So one can see that if a CFA, I say, which is expressly retrospective, is being drafted, it sets out both work done or to be done. And you can see that by looking at the Birmingham and Ford and Birmingham City Council and how that's worded in there.
So one might interpret this to say that it doesn't cover any work after the 24th of March 2015 at all. That would be amusing.
I'm glad, my lady, you brought that up, because I was going to make rather it's a flippant comment.
Cheeky point.
Yeah.
Sorry.
The lady's made it.
I'm sorry.
My lady has made it for me, because I was about to say that if the respondent's right, then it doesn't include any prospective work.
No, it's not. It's all a bit arid. Let's move on.
Can I ask about, if I may, are you going to make any more submissions about paragraph 179 of the judgment? when the judge talks about the cost judgment, where the judge talks about additionally taking into account the background knowledge which would have been reasonably available to the parties. My emphasis.
Well, my lord, you'll be pleased to note that I'm not, but my learned junior.
I wondered. That's the point your jury's going to talk
Yes.
about, right?
Yes.
Good.
So that's 4 and 5.
I wasn't quite clear. I looked at 4. That's part of 4 and 5, is it?
Yes.
Okay.
Probably be quicker and put better, but yeah.
So, Mr. Dunn, is there anything else in relation to
Not unless I can assist your lordship.
1 to 3?
No.
Thank you very much indeed.
Thank you.
And so, Ms. Gopal.
Thank you. My lords, my lady, yes, I'm dealing with grounds 4 and 5, which are grouped together as the factual matrix points. The first point, I think this arose very early on in the discussion, is the extent to which and when the factual matrix is engaged, and whether it is when there's an ambiguous term or whether it is relevant anyway. Well, it is in the authorities bundle at page 421, and that's in...
It's relevant. You always look at the factual matrix. I don't think that's in dispute, is it?
No, I think it was raised initially, so that was just one of the points that I wanted to cover off.
Anyway, your submission is that you have regard to the factual matrix.
Yes, exactly. So I will move on. The other point is about the extent to which the pre-contractual documents and the contemporaneous evidence is relevant. Now, what's happened, what the respondent's position appears to be, and what seems to have made its way as well to Mr. Justice Lavender's judgment, is that all pre-contractual documents are inadmissible when considering the interpretation of a contract. And what we say is, well, if we go back to the decision of Chartbrook, that isn't the case. And Chartbrook appears at tab...
We don't have Wood and Capita on the more recent authorities, do we?
We don't have Wood and Capita, no,
Which is a bit surprising.
Yes, it's tab 16, which starts at page 215. The relevant parts actually start at page 230. And paragraph 30, which says, to allow evidence of pre-contractual negotiations to be used in aid of construction would therefore require the House to depart from a long and consistent line of authority. That is not what we are inviting this court to do. What we are saying is that the same documents can also inform what knowledge the parties had at the time of the contract. And that is not the same thing as saying, yes, we're suggesting that the court should consider the subjective intentions of the parties. That's absolutely not our position. And we only need to go a bit further down in that judgment to page 235 and paragraph 42.
Yeah, and that's your point.
Yes. And so the same evidence, we say, is relevant to what knowledge the parties had at the time they entered into this agreement.
Of course, in Chartbrook, there was a claim for rectification.
That's right.
So all that stuff went in. The claim for rectification failed. But they then had regard to that material anyway. And when I was starting out at the bar, if you did that deliberately, you could be reported to the Bar Council. So it just shows how far we've moved on.
Yes.
Don't worry, it's not going to happen in this case.
Yes.
No, I wasn't
and
saying.
Mr. Bowl.
Yeah, I wasn't saying that in terrorem. I was just simply saying that's what happened in Chartbrook.
Yes.
And for those of us that go back a long way, it was quite a turnaround, as you can imagine. But anyway, you rely on 42 and you say, well, I can have regard to that material for questions of knowledge.
Yes.
Which is what the cost judge did, I think.
To an extent, yes.
Well,
The past working relationship features in the cost judge's decision, but not the entirety of the commercial imperative, we say, which is the point that was referred to earlier, that the parties had in fact entered into an unlawful oral CFA originally. Well, it was a private retainer to begin with, but the gentleman's agreement was that it was an oral CFA, which they then understood much later on that was unlawful.
The phrase the cost judge used was background knowledge.
Yes, yes. But then goes on, it does actually specifically refer to the working relationship between the parties. The commercial imperative point features less in Costs Judge Nagalingam's judgment, but is touched on by Mr. Justice Lavender in his. So the working relationship point is at 161 of Costs Judge Nagalingam's judgment, which is at page 100 of the full bundle.
Yes.
So that is part of
I
the
see.
background. We
Yeah,
say was
that's
actually
when he uses background knowledge at 179.
Yes.
He's referring to what he said earlier.
Yes.
Thank you.
The findings of fact on the oral CFA point, this again was touched on earlier, but just to take the court to the specific references of Costs Judge Nagalingam's judgment, it's at page 155.
155?
Sorry,
Paragraph?
155 at page 99 of the core bundle, where he first says in his second sentence, the claimant also accepts that there can be no notion of an oral CFA because a CFA must be in writing. So that point is made by Costs Judge Nagalingam. And that runs through to paragraph 157, where it said the language of an oral or verbal CFA has been discussed. Both parties accept no such agreement may exist in law. And then over the page at paragraph 159, so he does specifically say in his first sentence, the conclusion I draw is that the written CFA cannot be described as an amendment, variation, regularization, or otherwise, because an oral CFA is impermissible.
So he dealt with it fairly comprehensively.
He deals with the fact that the oral arrangement, which predates this particular CFA, was an unlawful CFA. Yes.
Well, I don't think he uses the word unlawful, but he says it's impermissible.
Yes, he says it's impermissible.
Yeah.
And,
So I don't understand what's the submission about on appeal. What do you say? I mean, he's dealing with it here.
Yes. So I'm trying to round up what the knowledge was of the parties at the time, as well as the findings that the cost judge has made on the oral CFA. And the oral CFA is relevant because we say that there was no commercial imperative for there to be a retrospective CFA in writing, because the parties had always proceeded on the basis that their oral CFA was a valid one.
So this all goes to the no commercial imperative point.
That's right, yes, our ground 4.
Right.
I appreciate or not want to be dealing with whatever the evidence in fact was of the parties, but there are two undisputed points that I'd like to draw the court's attention to. Is the evidence of Mr. Ingram, and that's in the supplementary bundle at page 294.
Is it appropriate for us to do that? We're not going to be teasing out the evidence. We're
No,
concerned with what
I
the
accept
cost judge decided and his findings of fact.
Yes, but what the cost judge does not find and does not necessarily have to deal with is whether the oral CFA, whether any of the parties had any reason to think there was a problem with that, because everybody's proceeded on the basis that that oral CFA was valid up to the point of the costs proceedings, it seems. So that is the only point that I really make that arises out of...
You say he does not find that the oral CFA what?
He does not find that any of the parties had any reason to think there was an issue with the oral CFA.
So what?
So where does that take us?
Yeah.
It takes us to this when you're construing this particular CFA, that knowledge must allow you to put yourself into the position of a reasonable party with all the knowledge that they need to construe the terms of that agreement. So why would it need to be retrospective if everybody already all the relevant parties understood that they had an oral CFA in place which was a valid one? And that's the commercial imperative point.
Right.
Paragraph 172 of Costs Judge Nagalingam's judgment does deal partly with the contemporaneous emails.
Sorry, I missed the paragraph number, forgive me.
172.
Yeah. Of the cost judge.
Yes, so this is page 101 of the core bundle. And what's said there is the contemporaneous emails demonstrate recent discussions as to including a retrospectivity clause in the written CFA. So it is clear that Costs Judge Nagalingam at that point is saying that the contemporaneous emails are relevant for the purpose of construing the terms of this CFA.
Do we have all of those?
Sorry?
Do we have all of those?
The contemporaneous emails, yes, they appear in the supplementary bundle as exhibits to the witness statement.
And we have them all, do we? All the relevant ones?
Yes.
And do you challenge his finding about that?
Well, there isn't anything in that evidence, in the contemporaneous emails, which supports a conclusion that there was a discussion on retrospectivity.
So you do challenge
Yes.
his factual conclusion at the end of paragraph 172.
Well, we say it's a conclusion that was not open to the judge to draw.
I don't think that is how I read the grounds of appeal. It doesn't say anything about your challenging a finding of fact, which you would only be able to do on a number of very narrow bases. Ground 4 is failed to take into account and failed to give proper weight to the matrix of fact, that there was no commercial imperative.
Yes.
I think you're going way beyond that, Ms. Gopal, are you not?
Well, it is, we say, part of the contemporaneous documentation obviously has been referred to by Costs Judge Nagalingam, but ultimately the entirety of it was not taken into account, we say. So it
Yes,
is a
but your
question.
ground of appeal doesn't say he failed to take into account documents and evidence which he ought to have done, and he did that in any way improperly, etc., etc. And accordingly, he came to a finding of fact which wasn't open to him, or something like that.
No, we talk
You don't
about,
say that.
No, we refer to the commercial imperative point, which cannot be viewed in isolation without referring back to how that came about, and it comes about from those documents. Because where else?
This is a second appeal. This is the Court of Appeal.
Yes, I appreciate that.
We are bound, as you are, by the findings of fact
Yes.
of the cost judge.
Yes.
Question of weight is a different point.
Yes.
That's commonly argued before us about weight.
Yes.
But as my lady says, it's not a challenge. There's no challenge here to a particular finding that the cost judge made.
No, we say that he hasn't taken into account what he ought to have in terms of the factual matrix, which included the commercial imperative not to have a retrospective CFA. So we do say that the commercial imperative cannot be viewed without considering what the emails were which formed that.
Well, why do you say the commercial imperative is important?
Because it is relevant to the knowledge that the parties had at the time they were entering into this agreement.
But the cost judge has made his findings about the knowledge that they had.
Yes, and
that
actually,
they'd done this before.
The cost judge says that there was a past working relationship. He doesn't find that when you say this is what they've done before, he doesn't find that they always had oral CFAs and then
Mr. Ingram's
they entered into
evidence is that at
retrospective.
all stages he, as the claimant, understood the written CFA would be retrospective and that this was consistent with previous instructions of Boyes Turner and consistent with a common pattern of work undertaken in insolvency cases where the instructed solicitor risked going unpaid or underpaid if assets in the insolvency could not be sufficiently realised.
Yes, but doesn't refer to the
But
fact.
there's your commercial imperative. It's all been done before.
Well, he's not saying, and that's not the reading of his finding, but he's saying they always entered into oral CFAs which were then converted into retrospective CFAs.
But he's just talking about the pattern of work. These are the
Yes.
findings by which you are bound.
Yes. But we say he's not finding that the pattern of work was that there were always oral CFAs originally, which were then turned into retrospective CFAs. Just talks about the general working relationship. And we say that that isn't a commercial imperative point because really there was an oral CFA. It's only that the parties didn't think it was unlawful when they entered into this agreement. That is relevant to what knowledge they had at the time they entered into this agreement. Because why would they have ever thought there was a need to make it retrospective? If they understood that their original agreement was valid, then what's the purpose of making it retrospective?
You say purpose. We're talking about knowledge. And the cost judge records at 167 that Mr. Ingram's evidence is that he understood the written CFA would be retrospective.
Cost judge also records, although I appreciate this is earlier on in the cost judge's
No,
judgment.
just deal with the sentence that I've just read. That's a finding of knowledge.
Yes.
So to the extent that, and I remain dubious about it, but to the extent that Mr. Ingram's knowledge is a relevant factor to the construction of the terms of the CFA,
Yes.
there is surely a critical finding of fact.
Well, it's only part of the knowledge. There was obviously findings that Costs Judge Nagalingam
So we
refers-
don't need to worry about commercial imperative. There might not have been a commercial imperative, but he understood it was retrospective, which is the issue we're concerned with.
Well,
Isn't that right?
well, actually, that is putting a subjective twist, I would say, onto.
I completely agree, but this is your ground for, not mine.
No, the subjective twist, we say, is the what their personal knowledge. What we say is what the court needs to look at is objectively what knowledge the parties would have had at the time and what the reasonable person putting themselves into the party's position would have interpreted the provisions of the CFA to be.
All right. Anyway, on the commercial imperative point, are there any other parts of the judgment you want to show us?
No, my lord, I think that covers my commercial imperative points.
Do you want to just, you were going to show us emails. I don't encourage you to do that now, but you want to just give us the references
Yes.
where you say, just give us the page references where you say the emails don't bear out the finding that the judge made.
So they are in the supplementary bundle from
I've been
page
just trying to
160.
flick through, but just give us the page numbers, would you mind?
So supplementary bundle from page 161
Page 161
of the supplementary bundle onwards.
onward. Thank you. Thank you.
I think some of the documents appear at 2 points, but they are at page 161 onwards.
Thank you.
And the final ground of appeal is the regulatory point, which I appreciate has been dealt with already earlier on today. What our point on the factual matrix there is that a reasonable person in the position of the parties would have expected to be advised about the issues of cost and what that liability would be, i.e. the liability would stem from before the agreement was entered into.
And how does that work? I'm looking at ground 5.
Yes.
You say the regulatory climate was such that they ought to have been advised about the consequences. How does that feed through? So the judge was wrong to dismiss that highly relevant factor. That is a background factor which you say then goes as part of the matrix of fact, which then goes to the construction of the CFA as a whole. Thank you.
And the point that isn't necessarily made in our skeleton but was raised earlier in oral submissions was about the fact that that wording also makes its way to the CFA itself.
Sorry, say again.
The wording of the code also makes its way to the CFA itself.
It's there in clause.
I could take the court back to that. So that is at page 109 of the core bundle.
Yeah,
And
clause
that's
6.
Clause 6.
Yes. There are some points made against me on the respondent's skeleton argument, which involve professional negligence cases and the knowledge and experience of the individual client. I don't propose to take this court to those, save as to say that the professional negligence sector and the test that is being dealt with on the breach of the duty to exercise reasonable care and skill is not part and parcel of the obligations on solicitors to provide advice about funding. It is not based on the knowledge of the individual client. The obligation exists anyway, and it isn't tempered by what you would normally consider when you're considering whether a solicitor has breached their duty to exercise reasonable care and skill in a particular case.
You say it's a regulatory obligation.
Yes, exactly.
To what extent does ground 5 depend on there being a clear breach of regulatory duty?
Well, it's ground 5 is really based on a lack of advice about funding.
Yes, but
So
the
it
ground
doesn't
says
mean-
in a clear breach of their regulatory
Yes.
duties.
Yes.
But again, I'm not aware that there's been any finding to that effect.
No, but there hasn't. The cost judge does not address whether there's been any advice given on the funding point. So the fact of there being no advice is in itself, we say, sufficient. There is no advice that is
Well,
given.
for us to make a finding of fact.
I'm not inviting this court to make a finding of fact. I'm saying that the cost judge Nagalingam does not conclude that they were advised on the not advised on funding in the context of the retrospectivity obligation and what it meant.
So, right, so which is the paragraph of his judgment that we need to look at?
But we say it isn't concluded, so it isn't.
Pardon?
We say it is not. He does not conclude.
So it's not there. So what do you say? I'm sure it's my fault. I'm not
Well, there is
following
an
this.
omission because what he is not he's not concluding that everybody was they were advised about it. He concludes that it's based on their working relationship. They would always have known about it. So that is the inference that needs to be drawn from that particular paragraph. There is no particular paragraph that says
Right, so he says that they'd always have known because of the working relationship.
yes.
Yeah.
He doesn't cover the regulatory situation at all, does he?
No, Judge Lavender covers the regulatory position. He ultimately says, I think it's 24.
In 29, Mr. Justice Lavender says, it may be that Boyce Turner were in breach of their professional obligations in that they did not advise the client adequately as to the effect of the CFA, and particularly its retrospective effect, but that does not affect the meaning of the CFA. And so, what is your submission in relation to that?
So our submission is that it is a relevant factor to the factual matrix. And it goes to the knowledge that the parties had at the time of the contract.
Yeah, and
Which is not that they were advised about funding.
So if there were an absolutely clear, crystal clear term as to retrospectivity, but the solicitor did not advise as to the meaning and effect and scope of the CFA, and the client said, I didn't understand this, would you say that the failure to give the advice meant that in fact the matrix of fact as to the knowledge of the parties at the time meant that it would be unenforceable retrospectively?
When you say unenforceable retrospectively,
It shouldn't be construed to be retrospective?
yes, well, the factual matrix is relevant irrespective of.
we know that.
Yes.
But when we put that question to Mr. Dunn
Yes.
a couple of hours ago,
Yes.
he said he accepted that if there was a clear term, then the regulatory position was a regulatory issue, not a question of interpretation.
But it doesn't.
But I'm not sure.
It doesn't, in itself, then fall away from the factual matrix.
Well, we understand
Entirely,
that, but
yes.
but what's the effect of it? You say it's relevant to knowledge.
Yes.
Let's assume that's right. What's the effect of it if there is a clear term that the CFA was retrospective?
Well, if there is a clear term that the CFA is retrospective and the client has been advised,
No.
And the client hasn't been advised.
so if the client has not been advised on it, then it cannot be the case then that it would follow it would be retrospective.
Why?
Because
If the term is clear. If the term is clear.
because you would still consider it as part of the factual matrix.
But that's not an answer. If the term is clear as a matter of construction,
Yes.
why would the absence of advice make any difference to the construction of the CFA?
Because it is still a relevant factor to what the client understood to be the case at the time. I should say, if we're dealing with this particular CFA, there's a duty under the contract to give that advice as well.
But that doesn't arise until you sign it.
But there is an ongoing duty to give
Could you just
advice about funding.
show me where the clause? Us where the clause
Yes, yes.
This is
Please.
6 again. Six.
Sorry.
It's page 109.
Clause 6.1, 109 of the core value.
Little
6.1 Roman 5.
Yes,
information about the likely costs of the case.
yes, exactly.
So at the risk of answering myself in terms of hyperbole, you say it doesn't matter what the clause says, if there's no advice, it's not retrospective. Is there any authority that comes anywhere near to saying that you ignore the clear terms of the contract and instead interpret it by reference on this point to one point of knowledge?
Well, it isn't one point of knowledge. It is
Well, this
all the
is.
knowledge that the
Well, no, this is one point. This is
Yes.
that no advice. You assert
Yes.
no advice.
Yes.
That
It
does.
That rewrites the interpretation of contracts.
Well, no, because it is asking the court to consider what the parties objectively understood.
We understand that,
Yes.
but that's why we've been careful to put to you the position if the clause is clear. If it isn't, then it's a completely different ballgame.
Well, arguably,
But if it
the
is-
arguably, if the clause is clear, they would have discharged that obligation.
Can I put an alternative proposition to you? The clause is clear. Let's say the clause is clear. The clause is clear. It's clear. The liability for breach of 6.15 would be different, wouldn't it? Mm-hmm. Supposing you had two clients, one of whom was given information and the other who wasn't.
Yes.
The clause would be clear. The liability, the liability under the contract, primary liability would follow, but there might be a counterclaim under for breach of 6.15 by the party to whom there had been insufficient or inadequate information. The clause the retrospectivity of the clause is not affected by 6.1.5, although its enforceability may be, depending on the circumstances.
Well, what we're saying is the regulatory obligation to give the best possible information makes its way as a contractual obligation as well. So it's what the parties expected, and that would have been their knowledge that there would have been advice provided in respect of funding. So it is not irrelevant when you're considering the factual matrix and the knowledge that the parties had. It must be relevant.
To the factual matrix. And would, on the assumption that there was a clear term, rewrite the term? Delete the term?
No, it's an interpretation exercise. So you wouldn't be deleting the term. And as I say, if there is a clear term which describes the liability for costs, arguably that is discharging the obligation to give the client the best possible information about costs.
Yeah.
So it's not a rewriting exercise. Thank you. Those are my submissions on the ground 5 point.
Thank you very much indeed,
Thank
Mr.
you.
Appellant.
I'll be very brief in
Mr.
terms.
Dunn? I thought we'd done with...
I was just going to make some concluding remarks, but I can see that wouldn't be helpful or...
Well, I thought that you had dealt with your grounds and that Ms. Gopal had dealt with hers.
If there's nothing further, my lady, I will
Okay,
sit back down.
thank you. Mr. Warnock.
My lady, I'll take first of all, it was suggested that there might be different rules which apply to conditional fee agreements between clients and solicitors. This is an area where Parliament has intervened, and the only requirement which Parliament has imposed on conditional fee agreements is that they should be in writing. It's also common ground. The other area where Parliament has intervened, of course, is in relation to consumer contracts. But it's common ground that this is not a consumer contract. It couldn't be because it was made, first of all, before the Act came into force, the 2015 Consumer Rights Act. And
Well,
second,
Mr. Dunn accepts now that the Consumer Rights Act isn't relevant.
so that being the case, it is purely a case of ordinary common law principles which apply to this contract. My lady and my lords, it's clear, are very familiar with those principles. We've set them out with reference to the relevant parts from Chitty, including what is effectively the Wood and Capita test as set out by Mr. Justice Popplewell, as he then was in the Lukoil case. The only specific point I would draw to your attention, because you've been taken to lots of examples of other wordings and other contracts, is what Chitty say about that at page 414 of the authorities bundle, paragraph 1650.
414,
14.
thank you.
And my lady and my lords will see that about halfway through 1650, the editors say some cases, including cases before the appellate courts, turn
Sorry, just give us a minute. I was noting something else.
414,
414.
and it's paragraph 1650. And I'm about halfway down on the right-hand side. It says some, and then some cases. Some cases, including cases before the appellate courts, turn entirely on the wording of the particular contract and do not require the courts to give serious consideration to prior case law. The precedent value of case law concerned with the interpretation of contracts is generally low, while they are authoritative in relation to the principles to be applied to the principles of the contract. It has been said that seldom, if ever, they're helpful in deciding how to interpret a particular contractual provision to refer to a case in which a court has interpreted different provisions of a differently worded contract made in a different factual context. And that is citing Tortesinas and Navona Management Company. My lady, as to my lords, as to the contract interpretation, we submit it is clear and unambiguous. It is clear what claim means. There would have been no need to put in the fact that it related to the solicitors had been engaged from a particular date, merely to identify the claim. Secondly, the fact that it has used the present perfect continuous indicates it's dealing with a situation which had started earlier and is still continuing. And we respectfully submit that the judge demonstrated really unanswerably the proper construction of the clause at core bundle page 76, paragraph 28 of his judgment. Paragraph 28 on page 76.
This is where he puts in the definitions into the clause. Just sorry to interrupt, just to go back. I think I was away when we did present perfect continuous. So could you just tell me what you're referring to or what that means? I apologise to the court for not knowing this.
I'm glad the Lord asked that question because I was trying to bluff it.
I'm very dependent on my learned junior for that. Okay. That's a good point. But it means that the way it's expressed, if one takes it from how the judges put it in paragraph 28, for the work done by the firm in the capacity, and it's the words of which the firm has been, it's the has been engaged. So what the clause is describing an event which started in the past, but which is still continuing. I hope I've got that right. But I'm pretty confident I have.
Otherwise, you were making a wider point about paragraph 28.
Yes, 28. It's not possible to read that any other way than what the clauses refer, what the contract is dealing with is the costs of the claim, which go back to the 30th of March 2012. It's clearly unambiguous, and Mr. Justice Lavender clearly demonstrates that by substituting the definitions for the defined terms. An awful lot has been made about a so-called unlawful oral retainer. I do quibble slightly with the word unlawful because what's really been described is an agreement which would be unenforceable, which is a slightly different thing. But in any event, the costs judge made findings on what the situation was. And there at core bundle, if we go to page 99, and at page 156, paragraph 156, he sets out what he thinks the true argument is. He says they find the claimant's argument is he entered into a written retainer by way of retainer letters dated the 31st of March 2011 and 28th of March 2012, which was later replaced by a CFA, which the claimant says is retrospective effect. And then importantly at 157, he says similarly, while the language of an oral or verbal CFA has been discussed during this assessment, both parties accept no such agreement may exist in law. In any event, it seems to me that discussions post-retainer, written retainer, were less reflective of a no-win, no-fee agreement and more reflective of an agreement that in the event of no realizations, Boyes Turner would either waive or reduce their charges. And at paragraph 160, he said the informal agreement described above having not been reduced to writing pre-2015, there is no definition of when to consider which would have triggered payment in any event. The pre-March 2015 written retainer exists in the form of retainer letters dated the 1st of March 2011 and the 28th of March 2012, which created a liability to pay costs. Secondary to that is the ability to pay costs, which is different to the conditions which are to be applied in order for the liability to pay costs to arise. So what the cost judge is effectively finding is that there was a written retainer, but an understanding between the parties not written down that unless realizations of assets were made, the solicitors wouldn't enforce it. And insofar as it's necessary to have a commercial imperative at all in the face of clear wording, it's clearly to the advantage of both parties that something which is unwritten, and certainly to the advantage of the client, that something which is unwritten like that is dealt with in a document which is written. And of course, the cost judge went on to find that this was in fact consistent, in this paragraph 167, which we've looked at a lot, with how the parties normally operated. In any event, my learned friend's point on this doesn't go where they would need it to take them. Because if everybody was blissfully acting on the basis that there was an oral CFA in place which covered everything, that doesn't explain why they need a written CFA at all. That would be as true for future costs as past costs. So it doesn't actually help with the issue of retrospectivity. And then a lot is made, and this is where the regulatory point comes in, a lot is made of the fact that, well, it said it's surprising there's no written document saying to the client that this agreement was retrospective in effect. But objectively, why does there need to be? Because both parties, in fact, understood it was to be of retrospective effect. And that's what the cost judge found at paragraphs 167 and 168. It was never, much has been made of the code of conduct and terms of the contract. The reason the cost judge doesn't deal with any of that is because none of it was argued before him. It wasn't put to the solicitor who was cross-examined that he breached any provision of a code of conduct. It wasn't pleaded that he'd breached a provision of a code of conduct. It wasn't pleaded that he was in breach of a separate term of the contract. And unsurprisingly, therefore, no breach was found by the cost judge. If it had been investigated, very relevant to deciding whether there would have been a breach would have been the fact that this is a sophisticated client who well understood and wouldn't want to be troubled with points which were obvious.
Operating in a specialist area.
Operating in a specialist area.
As defined in those paragraphs.
Yes. And of course, the agreement itself, the first point, time any point has been taken about the contract, specifying about cost advice, setting aside that it doesn't specifically deal with the issue that the court's dealing with, it's dealing with pricing. But it goes on to say that the client acknowledges that advice has been given.
Yes, that's what I read out at 15.2.
But in any event, Mr. Justice Lavender was clearly right to say that none of this is relevant to factual interpretation. It's a matter for the regulatory authority, and in fact, that's a point which this court made in Garbett and Edwards, 2006, One Weekly Law Reports 2907. It's at tab 12.
Is that Lady Justice Arden?
Lady Justice Arden, as she then was. And the tab 12, page 96 of the bundle.
Tab 12.
Page 96 of the bundle.
Yeah.
And the argument in that case was that there'd been a failure to comply with the code by solicitors in relation to giving an estimate of their likely costs to the client, and the paying party, ultimately not the client, was complaining that that rendered the whole contract unenforceable. And the Court of Appeal rejected that and essentially held that breaches of the code are a disciplinary matter. And if I could take my lady and my lords to page 108. And paragraph 29, Lady Justice Arden said, this is on page 108, the launch pad for the defendant's arguments is the indemnity principle, which I described at the outset of the judgment. In reliance of the indemnity principle, Mr. Morgan argues that if, as he submits, the effect of the receiving party's solicitor's failure to give an estimate is to render the receiving party's promise to pay his solicitors unenforceable, no fees are recoverable from the paying party. This is so even if the receiving party wishes to pay a solicitor and considers it appropriate to do so. Paragraph 31, I have set out the legislative framework. Estimates are required only by the code. The code is made pursuant to Rule 15 of the Solicitor's Practice Rules. These rules are made by the Council of the Law Society pursuant to Section 31 of the 1974 Act. In making these rules, the Council of the Law Society is acting in the public interest, and the rules have the force of subordinate legislation, see Swain and Law Society. The inference I would draw is that the code is there to protect the legitimate interests of the client and the administration of justice, rather than to relieve paying parties of their obligations to pay costs which have been reasonably incurred. But the rules are silent on the effect of a breach of a code on an assessment of costs between the parties to litigation. By contrast, paragraph 1 of Schedule 1A to the Act confers powers on the Council of the Law Society to impose sanctions on solicitors. If there is a complaint about fees, the Law Society can determine the amount of costs to which a solicitor is entitled or award compensation. And at paragraph 40, he says, I agree with Mr. Morgan that where a rule is imposed in the public interest, it would be surprising and unlikely if there was no sanction for non-compliance. But as the Law Society's written submissions point out, there are disciplinary sanctions for breach of Rule 15. Under Section 1A to the 1974 Act, the Council of the Law Society can determine what the fees payable for the client should be, and indeed may award compensation. It's a completely separate matter from the enforceability of the contract, and we submit a completely separate matter from the interpretation of the contract. Madam Junior reminds me that paragraph 36 is also helpful of the judgment. My lady and my lords, motto and trafigura. I I suspect Lord Neuberger would be surprised to discover that his dictum made in the context of a point he wasn't actually deciding as attracting such statutory force as has been suggested it has. But the point is that even taking the dictum at face value, it's unless the parties otherwise agree. And here it's clear the parties have agreed. It's a thin basis to say that there's some special rule which takes this type of contract out of the normal rules of contract. My lady and my lords, those are the points I have in reply, unless there's anything in particular I can help you with.
Thank you very much indeed. We have no more questions for you. That's lovely. Thank you. We have 5 minutes. Is it worth using those 5 minutes, or should we return at 2 o'clock, Mr. Dunn? How long will you be?
I'll be very brief in reply.
Right.
Because
And okay, well, let's do it then. Do it that way.
I mean, it's if the court is content with
No,
that,
let's do it.
because my learned friend obviously relies on his submissions. I appreciate that, but I'm just dealing with some of the points he raised. Garbett and Edwards is something of is not entirely on point, because if one considers what Garbett and Edwards is about, it's about in an inter-parties assessment, a paying party arguing that a breach of the code renders a retainer unenforceable or unlawful. And that is not
the retainer of the receiving party.
Yeah, indeed, my lord. Yes.
So it's effectively it's one step, as it were, closer than in this case. It's still similar, I suppose, in that it's a third party to the agreement.
Yes.
Making arguments about the agreement.
So it's Mr. Morgan in that case was in the position I'm in.
Yeah.
But Mr. Morgan was putting his point far higher. Firstly, because it was in the context of what costs are recoverable in an assessment. It wasn't a matter of interpretation of a contract. So that's the first distinction. But the second distinction is Mr. Morgan's argument was that if you are in breach of the code by virtue of the indemnity principle, because the client could essentially not have to pay anything under the contract, it said the contract itself would be unenforceable, or even it says, paragraph 40, it talks about being unlawful, all in the context of solicitors' estimates points. That's not what's being said here. That no one's suggesting that a breach of the code renders the entire retainer unlawful. The point is that, and I'm not going to go into this because it's been dealt with, but the point is that when one considers the facts at the time, one takes into account the advice or lack thereof when interpreting the contract. So it's not a Garbett and Edwards point. The motto and Traffic Euro point is I would simply say it would be surprising, to say the least, if there wasn't such a presumption. I know my learned friend is surprised that we raise it. I say we don't raise it above its true position. It would be astonishing, frankly, if there was anything other than a presumption that when a client contracts with a solicitor, they're contracting prospectively. And that has to be, I say, the starting point, that there is this presumption.
On that, I understand that point.
Yes.
Is there a difference? Is there any need for any difference between you used the example of client instructing a solicitor, but is it no more than a reflection of the fact that usually you have a contract between the parties at the start of the parties' relationship?
Yes.
So it wouldn't have to be a solicitor client. It could be any kind of commercial contract.
I would agree that it could extend to any kind of commercial contract, but the point is made in this particular case about a solicitor and client relationship, and this is because, and this is where I do differ respectfully with my learned friend, there is something different about solicitor and client contracts because of the way the power positions between the two parties. That is why one doesn't, as one would for any other commercial contract, rely on the usual unfair contract regulations or the consumer contract regulations. There is an apparatus of legal ombudsman, Solicitors Code of Conduct, the Solicitors Act itself. There is then all the authorities about, as I mentioned to my Lord Coulson before, about informed consent, which the leading cases on informed consent, for example, are about charging an hourly rate, and whether if the solicitor agrees an hourly rate with his client, there's no informed consent, the court won't enforce that contract. So we are in a different, it's not simply the case that this should be looked at as any other contract. And that is both reflected by the Code of Conduct, but also reflected importantly here by the fact that the solicitors choose to use the language of the code in their own retainer. Ultimately, the question has to be, is this an express CFA? So I could, and I'm sure my lords and my lady wish I would have done, I could have stood up and simply said that at the outset. Is this term clear? Is it an express term? Is it unambiguous? Is there only one way it could be read? And in the context of a solicitor-client relationship, is it lawful and appropriate for the solicitor to make an assumption about the knowledge of their client and expect them, having not received advice, to take this wording as if it were an express term as retrospectivity? I say it's not. Those are my submissions. That was almost to the minute.
Thank you very much indeed. I'm just wondering whether there's anything that Ms. Gopal wants to add.
No, there isn't. Thank you, my lady.
Thank you very much, and thank you very much to everyone for their work that they've put in and their arguments in this interesting case. We will reserve our judgments. Drafts will be circulated in the usual way to counsel and solicitors whose details have been supplied already, and that is so that you can draw to our attention obvious errors and typographical errors rather than re-argue your case. I know you'll be fully aware of that. And also we always hope that you will be able to agree a draft order and all the consequential matters therefore. And if you can't, please produce very short submissions so that we can make that decision on paper. So you won't have to come back, also because the judgment will be handed down electronically, as you will also appreciate. I ought to just draw your attention to the effect of the Counsel General for Wales case, and therefore warn you about circulation of the draft to other people other than those who have already given their details or had their details given. And if you need clarification, I suggest that you come back to us rather than do it and hope, put it that way. Thank you very much indeed.